نحمده ونستعينه ونستغفره ونعوذ بالله من شرور أنفسنا ومن سيئات أعمالنا من يهده الله فلا مضل له ومن يضلل فلا هادي له وأشهد أن لا إله إلا الله وحده لا شريك له وأشهد أن محمدا عبده ورسوله صلى الله عليه وعلى آله وأصحابه ومن تبعهم بإحسان إلى يوم الدين أما بعد. So today inshallah ta'ala we'll be continuing discussing the book Bulugh Al-Maram, and we'll be discussing the portion of this book that he discussed concerning matters regarding Ahkam al-Buyu. So discussing matters regarding Ahkam al-Buyu, and we have ended the chapter that he discussed regarding As-Salam wal-Qard wal-Rahn, regarding matters of concerning that of those topics regarding debts or taking out a loan, and also certain type of down payments. So today inshallah ta'ala that we'll be now discussing a new chapter. So we'll be starting a new chapter that the author Ibn Hajar عليه rahmatullah ta'ala, that he had titled Bab At-Taflis wal-Hajar. So Bab Taflis yani wal-Hajar. So we read the hadith as we normally do, then we'll have a discussion regarding what have been said by the ulama by way of the authenticity of the hadith. Then we discuss the meaning of the hadith, and then the mawdu of the hadith, and then we discuss the masahil of the hadith and the benefits of the hadith. So that will be the line that will be taken in discussing what will be mentioned. Nam.
Bismillah, alhamdulillah, wa salli ala nabiyyina Muhammad wa sallam. The Book of Business Transactions, Chapter 6, Bankruptcy and Seizure. Narrated Abu Bakr ibn Abdurrahman on the authority of Abu Hurairah radiallahu anhuma. We heard Allah's Messenger sallallahu alayhi wasallam say, if a creditor finds his very property with a debtor who becomes bankrupt, he is more entitled to it than anyone else. Agreed upon. And Abu Dawood and Malik reported the aforesaid hadith from the narration of Abu Bakr ibn Abdurrahman as mursal, with this wording: if anyone sells some goods on credit, and the one who buys them becomes bankrupt, and the seller does not recover any of the price of his goods, and he then finds his very goods with him, he is more entitled to them than anyone else. However, if the buyer dies, the owner of the goods finds his actual goods, he has most right to them. Al-Bayhaqi reported it with a full chain of narrators, but graded it weak, following Abu Dawood. And Abu Dawood and Ibn Majah reported the aforesaid hadith from the narration of Omar ibn Khalda, which has: we went to Abu Hurairah radiallahu anhu regarding a friend of ours who was bankrupt. He said, I shall certainly pronounce judgment about him in accordance with the judgment of Allah's Messenger sallallahu alaihi wasallam. Whoever becomes bankrupt or dies, and a person finds his actual goods with that man, he has most right to them. Al-Hakim graded it Sahih, and Abu Dawood graded it Da'if, weak. He also considered this addition regarding the mention of the word death to be weak.
Naam, so that's the hadith that have been mentioned by the author Ibn Hajar on this particular topic regarding Taflis wal-Hajar, that mention regarding bankruptcy and the person who have a restriction placed upon them regarding the use of their wealth. So they mention here, as to introduce this topic, that they discuss concerning what is Taflis and Hajar. So starting regarding Taflis. So this matter regarding Taflis as to what is meant concerning Aflas, where they mention that linguistically concerning what is meant by Aflas, as they say linguistically, man la ma lahu, is the person who has no wealth. So the person somewhat bankrupt or have no wealth present with them. And as the Prophet ﷺ mentioned hadith where he says concerning Atadruna man al-Muflis. So the Prophet ﷺ, he asked concerning the companions, Atadruna man al-Muflis, who is the person who said to be a Muflis. So the companions anhum qalu al-Muflis fina man la dirham lahu wala mal. So the companions, they went on to answer regarding that, as for the Muflis, that what they know the Muflis to be, that is with us, is the one who has no financial wealth, no dirham, no money, nor mal, or any form of things of property. So that's concerning what is the companion understood of Muflis, which is that meaning is the linguistic meaning. So they took the linguistic meaning of Muflis, as it states here, huwa man la mal lahu, is the one who does not have any wealth. So as for the istilah meaning of Muflis, shar'an, that the ulama mentioned regarding al-Muflis, as they mentioned, you have different definitions that are given. Of those who mentioned that a muflis is the one they mention, man tazid daynuhu ala mawjudi. That they mention that the one whose debt increase what he actually has, what he possesses and owns. So the person whose debt is far beyond what he actually possess and able to can repay. So also it is mentioned, as they mentioned, that also muflis, some will mention man la malahu, the one who does not have any wealth. Then others who have mentioned, Sheikh Bassam, that they have mentioned regarding al-muflis, man daynuhu, the person whose debt, akthar min mali, that a person whose debt it is more than what he possesses. So the person's debt, what he owes to other, it supersedes that actually it is more than what he actually has. So that's concerning the various definitions that are given regarding al-muflis. So that's concerning al-muflis as one of the words that they mentioned here. Then the second word that they mention, al-hajar. So hajar that they mentioned hajar is al-man wa tadiq. So the person has somewhat a barrier or restrictions are in place. So there's a barrier, a blockage have been put in place, or something which is tadiq, making things, putting restrictions on the person. So they mention istilahan hajar. What is meant by this? Man al-insan is to forbid a person or to block a person min tasarruf fi mali, so to block a person, to have restriction, place restriction on a person regarding how he uses wealth. لسبب, due to factors or reason. So al-hajar, that they mention is a person that restriction has been placed on the person regarding his use of his wealth and based upon reasons. So that's concerning what are meant by those words as mentioned here as to these terms and what have been mentioned by there, and we now discuss what is mentioned by the Sharia regarding the person who falls into. So they mention the word taflis, as they say, bankruptcy, of being the bankruptcy as a single word. Then they have mentioned regarding concern that the person that certain restrictions may be placed on a person regarding the use of his own wealth, and this could be, they mention, two reasons: reason regarding others or regarding himself. So what regarding concerning that the person that they may put restriction on the person regarding that due to others, so considering about other people, so restriction may be placed on a person regarding how he use of his own wealth, that it could fall into because of other people being affected by this. Where I mentioned that it could be regarding concerning that person, that restriction or place where that he himself, that he falls short of the person, he has no wealth and he wants to use other people's wealth or borrow from other people. So there's a restriction regarding, placed upon regarding him so as to protect others. The second case, that a person might have some wealth. So the case the person has no wealth, so restriction of the place, and he owes other people things, so restrictions are placed on him. Another case where the person could be that he has some wealth, so restrictions are placed on a person that he has some wealth, but his debts and what he owes other people, what he has to pay out to other people, is beyond what he possesses. So he does have some wealth, but what he owes, what he needs to pay other people, is far beyond what he possesses. So in that case, that people can seek of their wealth and seek ways, and they of ways that the people go back to the judge, a judge, for them to intervene regarding the person. He has some wealth, but what he owes other is much more a way of them to retrieve some of their wealth. So that goes back to a qadi or someone to arbitrate in that matter. Another case concerns a person that an yakun lahu mal, that a person has some wealth that according to his debt. So he has enough wealth that he's able can pay back his debt. He has enough wealth that he can pay back his debts or what he owes others. So in that case, then it is upon the person that he must pay back those debts. He must pay back those debts accordingly. And also a case where that so mentioned that the person who has less have more debts. In this other case, the person have wealth with his, he have enough wealth that he can actually pay his debt. So the person has the wealth that he can pay back. So again, in that case, that the person that restriction can be placed upon him, and the person that people are paid because he has the wealth that he can pay them. So, but he does not want to pay them, and so that intervention can take place where he's forced to pay those people. He's forced to pay those people, and with this also that there can be restriction placed upon him to ensure that those people are repaid. Restriction can be placed on him so those people are paid, and that goes back to the qadi, the judge, to look at those matters and to rule accordingly. So that's concerning of cases where restrictions are placed on a person, and also them. Another restriction can be placed on a person regarding how he use of his wealth because of other matters, factors. It could be of those sabab. Those reasons could be that that person that some restriction is placed upon them, that the person is below the age that they're still a youngster, they're still a child, so they're not allowed to purchase of certain things, except so restriction is placed regarding them misusing of their own funds because of them being a child. Or the person may be majnoon, that because of insanity, that there are then restrictions are placed regarding them spending or buying certain things. And also the person may be of one who's not mentally fully sound enough. They have some level of soundness in decision, but they're not to a level where they become fully responsible. So they will say the person like a safi, so some level of, they're somewhat very immature, or the person somewhat very, that we say that as the person that not have some level of not being that responsible enough to spend of because of the immaturity of their mind or silliness of their actions. So those are cases that a person restriction can be placed on a person's spending of their own wealth. So then after the next matter to be discussed is the hadith. So the next matter to be discussed is the hadith that have been mentioned in this particular discussion. So they mentioned one hadith, but they have three parts to it. So the first narration of the hadith they mentioned, and Abu Bakr ibn Abdul Rahman and Abi Hurairah radiyallahu anhu قال سمعت رسول الله عليه السلام يقول من أدرك ماله بعينه عند رجل قد أفلس فهو أحق به من غيره متفق عليه. So the first hadith that was read that mentioned the man adrak, the person who have found his wealth with someone who is bankrupt, then he has more right to this. He has more right to retrieve of what he has sold that person. They mentioned hadith muttafaqun alayh. So the first hadith they mentioned of Abu Hurairah, that the hadith by way of takhrij in general, that the hadith is sufficient for the hadith regarding authenticity, the hadith muttafaqun alayh. So the hadith muttafaqun alayh, then that it suffice for it being agreed upon between Bukhari and Muslim as being said to, that shows it authenticity. So the hadith of Abu Hurairah, it is also collected by Bukhari, Imam Muslim, Abu Dawood in his Sunan, Nasa'i, Tirmidhi, Ibn Majah, wa Ahmed. So it's in, as they said, Kutub Sitta. Bukhari, Muslim, Abu Dawood, Nasa'i, Tirmidhi, Ibn Majah, and also Ahmed in his Musnad. Others also that have been included, Ad-Daraqutni wal-Bayhaqi. So Daraqutni wal-Bayhaqi also collected this hadith, and they mentioned the hadith that it goes back from all of these on the chain of Yahya ibn Sa'id and Abu Bakr ibn Muhammad ibn Amr ibn Hazm and Umar ibn Abdul Aziz أخبره أن أبا بكر ابن عبد الرحمن ابن حارث ابن هشام أخبره أنه سمع أبا هريرة عنه يقول. Then that's the hadith. So the hadith that is mentioned first, that this hadith goes back to, it mentioned Bukhari or Muslim. The second narration of the hadith mentioned Rawahu, that he mentioned Rawahu Abu Dawood wa Malik. So the next narration is collected by Abu Dawood wa Malik min riwayat of the narration transmitted by Abi Bakr, this narration of Abi Bakr ibn Abdurrahman Mursalan Bilaf. So this hadith is mentioned Mursalan. So Al-Mursal is of those terms used by the ulama of hadith, indicating that a narration of hadith that have been something that's been mentioned or said upon the Prophet ﷺ by a tabi'i. So a tabi'i that have narrated upon the Prophet ﷺ directly. then that is referred to as mursal, hadith al-mursal. As what is now, so that is hadith al-mursal. Even the word mursal at times may take a more broader meaning, but in this context, that he means the hadith of a tabi'i being narrated upon the Prophet ﷺ. They mention bilaf, then that wording goes, أيما رجل باها متى فأفلس الذي ابتعه, that the person, any person who have sold something to a person who is said to be bankrupt, after selling the person that item, ولم يقبض الذي باعه, and he hasn't yet retrieved what he have min ثمنه شيء, he hasn't received any payment for that item, فوجد متاعه, and he finds the item that he has sold بعينه as it is, فهو حق به, then he has more right to it. وإن مات المشتري, even if the purchaser, the one who has the one who have purchased the item have passed away, وصاحب المتاع أسوة غرماء, and that so that the one who, the owner of the item, then he then becomes like the other debtors. Then I mention ووصله بيهقي وضافه تبعا لأبي داود. So they mention that what he meant by this, وصله بيهقي, that Bayhaqi also, I mentioned that it has is mentioned with a complete chain, going back to the Prophet ﷺ, without any one being missing. That I mentioned وضافه, but also he owed it to be daif, meaning the narration that is mawsul, that have a full isnad. ضعفه تبعا لأبي داود, but Bayhaqi owed the hadith to be daif, mawsulan, following the footstep of, or following the ruling of Abu Dawud. Imam Abu Dawud as-Sijistani, who they mentioned, also narrate the hadith. So they mentioned, as for the second hadith that had been mentioned, Rawayat Abu Bakr ibn Abdul Rahman, that is in Muwatta of Imam Malik, and also Abu Dawud in his Sunan, min Tariq, and it goes back to Ibn Shihab al-Zuhri, and Abu Bakr ibn Abdul Rahman, ibn Harith al-Harith, ibn Hisham, and Rasulullah alayhi wasallam قال, they mentioned that from Abu Bakr ibn Abdul Rahman, ibn al-Harith, ibn Hashim, narrated upon the Prophet ﷺ directly. Then that is mursal, as is a tabi'i. So they mentioned that this narration is collected by Abu Dawud, also about Abu Dawud, and also Bayhaqi, also of a different isnad, where also Abu Dawud, another isnad it mentioned, min Tariq Muhammad ibn Walid, and Zuhri, and Abu Bakr ibn Abdul Rahman, and Abi Hurairah anhu, and Nabi alayhi salam. So that also have the full narration. So Bayhaqi, that's the narration of Bayhaqi, and also Abu Dawud, that the person that was missing, again they mentioned Abu Hurairah, the one that was missing, that forms the Mawsula is Abu Hurairah. So they discuss concerning which of those is more correct, the one which is Mursal or the one which is Mawsula. So they mentioned that according to Abu Dawud wa Daraqutni wal Bayhaqi, but Abu Dawud, he said regarding the hadith Malik Asah, with the narration of Malik, which is the one which is Mursala, that is more correct. So that's the view of Abu Dawud. But Abu Dawud, so that's the working, what is mentioned by Abu Dawud. And they mentioned that Abu Hatim, that Yani al-Mursal, قال al-Bayhaqi لا يصح, concerned that a Bayhaqi mentioned regarding the narration which is Mawsula, that has a full narration, a full chain, a complete chain, that is, you mentioned, لا يصح, it is not authentic, Then they state concerning Abu Hatim, وأبو زرعة, so Abu Hatim, وأبو زرعة, that they mention as-Sahih indana min hadith az-Zuhri and Abi Bakr ibn Abdul Rahman and Nabi alayhi salam mursala. So that's what is for them, that what is the more correct version or narration of the hadith is that the hadith is mursal, with an incomplete chain from the Sahabi narrated upon the Prophet alayhi salam. So that's concerning that particular narration. So of the ulama, all the hadith is mursal, is more correct narration of the hadith, not the one which is mawsula. Then the third hadith that they mentioned, the one of Ibn Hajar, when he mentioned this hadith in Fath al-Bari, he mentioned, قال Ibn Hajar in Fath al-Bari, قال المشهور إرساله, that a hadith, that what is more mashhur, what is more known, that a hadith it is mursal, which is the hadith that we just mentioned. As for the third hadith that is mentioned, or narration of the hadith, that is in the Abu Dawood, Ibn Majah, Daraqutni, and also Al-Hakim. So the third narration of this hadith that it mentioned where it says concerning Rawahu Abu Dawood wa Ibn Majah min riwayat Omar ibn Khalda قال آتيت أبا هريرة رضي الله عنه في صاحب لنا قد أفلس. That he mentioned, I came to Abu Hurairah رضي الله عنه regarding a companion of mine who have gone bankrupt. فقال أقضين فيكم بقضاء رسول الله عليه وسلم, that I will judge you with the judgment of the Prophet عليه السلام. I'll judge according to the Prophet Islam, judge this case. فقال من أفلس أو مات, the one who is bankrupt, أو مات, or passed away, فوجد رجل متعه بعينه, and a person has found his wealth, فوهق به, that he has more right to it. So that's going to mention صححه الحاكم ضعفه أبو داود هذه زيادة في ذكر الموت. So they mentioned that this is the third narration of the hadith. So as for this hadith, it is found in the Abu Dawood, Ibn Majah, Daraqutni, wal Hakim, amongst those who have narrated this hadith. And as for this particular narration, that they mentioned that in this narration there's a narrator that is Abu Mu'tamar ibn Amr ibn Rafi. We have some discussion between the ulama regarding him. So you have some discussion regarding that particular narrator in the hadith. So one of narrator, Abu Mu'tamar ibn Amr ibn Rafi, that of the ulama, that wathaqahu ibn Hibban, all him to be a valid narrator. Ibn Abdul Bar قال ليس بمعروف بحمد الحديث, that is not known for carrying of hadith. He's not known. قال الذهبي لا يعرف. الذهبي قال is not known. He is not known. ولم يذكر ابن أبي حاتم له إلا راويا واحد وهو ابن أبي الذئب. But and Ibn Hajar قال مجهول الحال. مجهول الحال. So Ibn Hajar, so you have some criticism about that particular narrator. You have some criticism about that narrator who's Abu Mu'tamar, that there are some criticism regarding him. So based upon this, that's one of the ulama that as mentioned here, that he mentioned, that da'afahu Abu Dawood, that of the ulama who authenticated with the Hakim, as he mentioned in his book Al-Mustadrak. But as for, they mentioned Abu Dawood and others who have criticized this hadith. So with this, they mentioned that of the wording, though, they mentioned that Abu Dawood, of the ulama who can somewhat they criticize regarding the word man aflas or mat, that the word mat being mentioned is not part of the hadith. That all that concerned to know that that ziyada is somewhat criticized. That ziyada, it is criticized. Even Arnaut, and is he mentioned regarding that as sahih, duni, that he mentioned hadith is sahih. And Sheikh, and I mentioned that the hadith is sahih, but he mentioned that without the word mat, the person dying, then he mentioned hada isnad daif, that isnad is daif li jahalat Abi Mu'tamar, because of the not having information about the state of this narrator, Abu Mu'tamar ibn Amr al-Rafi. So you have that discussion regarding that particular Abu Mu'tamar that is mentioned here in the hadith, that the ulama have and others that may be discussed in this particular hadith. So I mentioned Al-Rafa, then Al-Rafa is the person that is under discussion. So that inshallah ta'ala, that so the hadith on the discussion between the ulama are those who authentic the hadith and those who hold the hadith that due to Abu Mu'tamar, that the hadith is weak. The hadith is weak, but others who may hold the hadith to be sahih based upon those other narration. Or those who hold the hadith to be sahih is based upon the other previous narration. So that's something regarding ilm al-hadith and what is said about this hadith. So as for this particular hadith, and discuss concerning the mawdu' regarding the person who's bankrupt. So regarding the person who falls in a state of bankruptcy, then where he owes other people taking things that he hasn't paid for, can that person retrieve that item? Can the person retrieve that item? So as for the masail that are now covered in this particular hadith, that they discuss at some point we got a hadith here that is mentioned by As-San'ani that Abu Dawood didn't concerning Abu Dawood didn't clearly all the hadith to be daif. It didn't mention concerning, we go back to the hadith Abu Dawood, that there's no mention clearly from Abu Dawood that he all the hadith to be daif. But that's a point to take into account. As for what is mentioned regarding concerning the masail that can be taken from the hadith, they mention man adrak ma lahu bi'ayn. So discuss regarding the person who have sold someone an item and the person has been declared as bankrupt, and that item that was sold, that there was no payment that was made on the item, can the person who sold, the seller, can they go and retrieve that item that has been, what was sold to a person, but that person is bankrupt and have not paid anything for that item? So on this matter, the ulama that mentioned regarding on this matter, that this hadith is generally, that I mentioned that the ulama, the jumhur of the ulama, that all concerned that the person that he has a right that he can go and take back his item if the item is still in its condition as it was given. So the item is still in the condition that it was given initially, and the person cannot pay for it, that the one who have sold him the item, who have given the item, they can go and take it back because the item is still intact as it was given. So they mentioned that person, they have more right to retrieve it than anyone else. They have the more right to retrieve than everyone else, and that's the view taken by Jumhur of the ulama. That's the position taken by Jumhur of the ulama. That you mentioned that they mentioned the Hanafiya, the ulama of the Ahnaf, that are all concerned their position that they go against this, where they mention which against the hadith. They said hadith 1 khabar ahad, according to them, لأنه خبر الواحد خالف الأصول. So according to them, this hadith which is a khabar wahid, that it goes against their usul. So even though the hadith is authentic, but they already have certain usul in place that they are working with. So they say that another hadith, which is khabar wahid, it goes against their usul, which is that the sila, the item that have been bought, that the fact that it's been sold to someone, it becomes their property. The item, because it was sold and taken by someone, so it becomes their property, and so no one can just go and take it except with their permission, because that becomes their belongings. It becomes of their belonging. So that's the call of Jumhur of ulama, and they use this hadith as their evidence. They use the hadith as their evidence. So Ibn Abdul Barr, I have mentioned regarding that the view of the Ahnaf, that is responds to them. They call them huwa mimma yu'ud alayhim, of those things that have been put against them, min sunan allati raddaha bighayri sunnah. So of the things that have been put against them is because that they have refused or not aligned with the sunnah based upon with other than a sunnah, but based upon their usul. So they said the hadith is there, but they are not acting according to the hadith based upon of their usul, and there's no other hadith that contradicts this or any clear evidence that they can give regarding this. So they mentioned that when they mentioned وَأَدْخُلُوا النَّظَرَ حَيْثُ لَا مَدْخَلَ لَهُ فِي, where they can someone put their own nazar, their own reasoning, their own view on the matter, without per se having la madkhal, where the reasoning doesn't come into play in this case, because there's a clear, as I mentioned, wala madkhal lid nazar, that there's no room for a person to have their own opinion, ma sahih al athar, when there's a authentic text. So if there's an authentic text, then there's no room for a person to come with their own ideas and their own opinion that contradicts that text or go against that text. So that's concerning of those masail that is mentioned here regarding concerning this matter. Then they mention regarding concerning the next matter they discussed between ulama, if the person have sold an item to a buyer, that buyer have taken the item and they have paid a part of the payment, the cost. So they paid not the full cost, but a portion of the cost have been paid. Now in this case, can the one who sold that item take it back? Because the person, when they sold the person the item, the person paid them a portion of the cost. For example, the person sold a car that value at 10,000, but the one who have the seller have received half the cost, which is 5,000, and only 5,000 remain to be paid. Is in this case, and the person who bought the car have declared bankruptcy, have fallen into bankruptcy. They are unable now to pay the remaining, but the car is still intact and hasn't been used, and it's still there in the person's garage, brand new as it was sold that day. Is now the one who sold the car allowed to go and get that car, but the person paid a portion of it. On this matter, that the ulama have a khilaf between the ulama. They mentioned ذهب Imam Ahmed وإسحاق وشافعي في القديم إلى سقوط حق الرجوع, that in this case that the car should not be taken back. It's now been removed, and and that person now doesn't have more precedent over others regarding those who that person may owe them things, even the person who have claimed bankruptcy. So the one who, or the dealer who sold him the car, or the person who sold him the car, that because he have received a portion of the payment for the car, then he cannot just go and take the person's car and have more right to that car. Then they mentioned regarding concern that, and the reason for this, they mentioned the Hadith, the Prophet mentioned that أيما رجل باع متاع فأفلس الذي ابتاعه ولم يقبض الذي باعه من ثمنه شيء. So they mentioned that a person, that if you sold someone something and the person then fall into bankruptcy, then لم يقبض, you're not allowed to take back that thing except the person didn't pay anything. They mentioned that you are not allowed to take back من ثمنه شيء unless the person didn't pay anything. So the person pays something, then you are not deserving, you are not first in line to receive that item. So they mentioned regarding concerning that. Then I mentioned that in some narration they mentioned وإن كان قد قضى من ثمنه شيء, if the person paid something, فهو أسوة غرماء, it becomes like an equal par as the other debtors of that person were gone into bankruptcy. So you don't have more precedent, priority over others, because the person already paid you a portion of the item that you sold them. So that's concerned that matter. So you find a person, so in this case they mentioned that that's the rule taken by some of the ulama who have taken that opinion that you per se don't have priority in taking back the item that you sold, because you receive a portion of the cost. And that is, they mentioned that the item is still intact. If the item is still intact as it was sold. And next case regarding if the item have now changed. So the item of somewhat, whereby things have been, the item of somewhat you have added something additional to the item, or the item have been depreciated where it has lost its what it was originally. Then what becomes the case of it? So some change have occurred where things have been added or things have been removed from the item that was given initially. In this case, the ulama have mentioned regarding concern that in that case, so the person paid for the full item or did not pay for the item, then I mentioned ذهب أحمد. Then they mentioned ذهب about the ulama on this matter concerned that ليس له رجوع. It's not for him to go back and take the item because it have changed. It's not as you have given it. So on this case regarding concern a person that unless there was a condition regarding that a condition was made, but on this matter, they mentioned that the person that because things have been added to what was given initially, or things have been removed, decrease from what was given, then the person, the one who sold the item, doesn't have priority in taking back because it's not what he gave or what was sold. So in that case, he's not the priority in retrieving or receiving back that item. But of the ulama, they mention Al-Malik, wa Shafi, wa Awzahi, that if the item did change, that they mentioned that قالوا إنه أولى بعين بعد تغيير والنقص. That so of those who mention that is awla after the item have either increase or decrease. Things have changed for it, that is still more deserving. So he's more deserving the item, even though some things have changed regarding what he initially gave. So those are some of the matters that are discussed in this particular masala regarding these hadith. So this shows regarding concern the person regarding a debt that either the person will declare as in bankruptcy, that that person who have taken an item from others, bought something from others, if the item that he's bought is still intact as it was bought, then the seller who sold him the item, they have more right to it. Or if he's a state of bankruptcy where he cannot pay for that item, or if the person, second case of the person have bought an item, then he has been declared bankrupt. He's unable to pay for that item, but he has already paid a portion of the costs, portion of the payment has been given to the one who sold him the item. Then in this case, then the person who sold the item is not of the priority regarding retrieving the item, if the item still remain as it is, because he receive a portion of the payment. Then the third scenario, that a person bought something, then fell into bankruptcy, had been declared bankrupt, and the item that he received, the item have changed. The item have changed, then you have a discussion between the ulama, those who hold that. So a discussion between the ulama as to those who hold that, because there's some change have occurred where the things have added or been removed, that the item is not the sale, and the condition that the item should remain the same. Of those who mention no, that the person who sold the item doesn't have priority in retrieving it back because the item have changed and it's not as he was given. The hadith, the item should that remain in its original form. So they mention as the hadith mentioned that man adrak malahu bi'ayni, the person who finds is the item as it was given, without any changes, addition or subtraction. In that case, they're more deserving, but if it is not, then they are not more deserving. So you have that discussion between the ulama as to if the case of the changes, that the person should he be compensated, still be compensated or not, or become that he doesn't have, but he is to be compensated for what he sold the item for. So with that, inshallah ta'ala, some of those masail that are discussed in this particular discussion. So this inshallah ta'ala will end our discussion. وبالله تعالى توفيق وهذه السبيل والآخر دعوانا الحمد لله. السلام عليكم ورحمة الله.